computer, VPN, but switching it to 365 before we had any training on it, that was absolutely insane.
Yeah.
That was really a bad move. So like the way if you try to send a Word document right now, if I do,
I know, I went through this.
it's
I couldn't send a link.
can't send a link.
You're gonna have to go through what I went through.
Yeah.
Just time consuming.
I can't send a Word document. Right now, I can't send a Word version. It's not, it's a read only. And I don't know how to do it, to make it not a read only. You know what I mean? No. You want to see it on my computer? Wait, when you want me to scroll down? This is Monday, September. Okay. That piece for rest. Yeah, I want to.
Hi, Jerry. This is Claire in 102. I might need a little help this morning. I've gotten I think I'm live streaming, but I don't have my Zoom screen up, like, that on the bench where you can see everybody. I don't know. It's weird. I think I'm almost there. Thank you, Joey.
So. Gonna get in. Yeah, it's just a lot. Well, it's. Yeah. Yeah, anyway. I don't see a problem.
I thought I was doing so good.
I'm sure you're
And
doing
then
fine.
this is what it went to when I clicked on, the red button for live stream. It went to this. How do you do that?
Now I can send a link.
So right down here, they just put Zoom down on the bottom.
Oh.
And for some reason, sometimes it doesn't show like that it's active on here.
Uh-huh. That's okay. It is underlined, actually.
Yeah, it is.
Cool.
So
I just.
yeah, no, I totally get it.
I think
I think you're good. Good work.
Yeah.
And put me out of a job soon.
No. Heck no. You can pay me enough to do your job.
It's fun.
Please rise. The Superior Court is now in session. The Honorable James J. Dixon presiding.
Please be seated. Thank you. Court is back on the record in the matter of Lisa Steele et al. Versus Olympia Early Learning Center et al. Clause number 11-2-995-2. Mr. Bolasina, if you'd be kind enough to approach the witness stand, I will re-administer the oath in light of the fact that this is another day. Please raise your right hand. Do you swear or affirm the testimony you are about to provide is true and accurate to the best of your knowledge?
I do.
Thank you. Welcome again. Please have a seat in the witness chair. Mr. Cochran, you may continue.
Thank you. Governor, with your permission, I'm going to put up the chassis factors.
Yes.
And Mr. Bolasina, do not be alarmed. We know that you are not here as an expert witness, nor are you responsible for knowing the chassis factors. I do it more to serve as a guidepost for myself and hopefully for the court to some extent as I do your examination. We finished the day yesterday going through some of the early work that you did on the case in 2011 after you were assigned in May of 2011 by Philadelphia Indemnity to represent the Olympia Early Learning Center. One of the things we did yesterday was look at the plaintiff's complaint, and I'm pointing up here on our chassis factors at the merits of the releasing person's liability theory, that being the plaintiff's, and you understood from the beginning that the plaintiff's theory was a well-recognized negligence theory, right?
Correct.
Leading.
Well, it is a leading question. Please rephrase.
In terms of what you saw from the plaintiff's theory, how would you characterize the negligence theory in terms of its acceptance for a long time in Washington State?
I would characterize it as a generally accepted theory of liability in that type of case.
Am I correct in understanding that you understood that there were no summary judgment motions that were likely to win in this case, given the general nature and well-regarded nature of the theory?
Well, that varies by claim, and I would agree with that on the essay claim that I would gauge the summary judgment potential at about 1%.
Okay, and let me phrase it this way. Was there ever a point in any correspondence between yourself and Philadelphia Indemnity or anyone else where you said, I intend to bring a summary judgment motion to dismiss a particular claim?
Not that I recall.
Right. As of September 14th, for example, of 2012, had you brought a single summary judgment motion against any plaintiff?
No.
And so as we look at the merits of the releasing person's liability theory, would you agree that there were no claims of any of the child plaintiffs or parent plaintiffs which were subject to a summary judgment dismissal?
That is correct. Well, actually, are you saying that
As a result of you bringing.
right? There's two questions here.
Oh, that's okay. We just want to make sure that the court reporter can accurately record the question and then the answers. So I'll ask the witness to continue. Go ahead.
If you want me to comment on, the likelihood of summary judgment in each case, then that would vary. But if you just wanted me to comment, were there summary judgment motions pending, then the answer is no.
Right, because we. Sure.
I said, if you want me to comment on the likelihood of summary judgment in each case, given the individual factors, then I could do that. But if you just want me to answer were there any summary judgments pending, the answer is no.
Right, and I think for purposes of our examination of what the status was in September of 2012, were there any summary judgment motions that have been filed against any of the plaintiffs in the Steele versus Olympia Early Learning Center et al. Litigation?
And by et al., I assume you mean all 6?
Right.
No.
And in fact, I mean, all 13 of the plaintiffs, because there were 6 children and 7 parents. Am I correct in understanding that you had not filed a single summary judgment motion as to any of their claims?
That is correct.
And for example, there were no civil RICO claims or something which might have been characterized as inappropriate for the case. These were just negligence claims, right?
Yes, that's my memory.
And in terms of the merits of the released person's defense theory, we were talking about the defense theory a little bit yesterday. We heard that one of the bases of your defense was the credibility of Eli Tabor, right?
Yes, for 5 of the 6 children, yes.
And another aspect, and as to the 6th child, S.A., there was a conviction, there was admissions as to what he'd done to S.A., and so there wasn't even a defense theory, at least as to causation and damages, right?
As to liability and damages, as to liability, that is correct. There was no question that the abuse did occur.
And in terms of the liability or the defense theory as to S.A., you were essentially in correspondence with Philadelphia acknowledging that case was very problematic, right?
Yes.
Meaning you felt concerned that there was going to be a plaintiff's verdict in the S.A. case as a result of the facts in that case.
Yes.
And that was an opinion that was shared with you in response emails and correspondence from Philadelphia Indemnity, right?
Yes.
So Eli Tabor was one aspect of the defense theory. Rose Hordahl, one of the program director, the fact that you liked her and believed her was another aspect of the defense theory. Is that right?
These are all leading questions. Could we?
They are leading questions. Can you please rephrase, Mr. Cochran?
I will. I would submit for the record that this was my adversary. And that, I should be able to, I think that I should be able to treat him as an adverse witness. But.
Yeah, I don't think this witness is an adversarial witness. He doesn't impress the court as an adversary witness, at least at this point, and hopefully doesn't degrade into that.
So can you tell us whether Rose Hordahl's credibility was one aspect of the defense theory?
No, I did actually comment on that I believed her, but I commented on the other side that as to the essay claim, there were a number of witnesses who would testify that she did see red flags and ignored them, and that those would be likely persuasive to the jury.
What evidence have you gathered from your witness interviews and from your document review about Eli Tabor being a problem really from the beginning of his employment forward?
That was, yes, I did gather that both from witness interviews and document review, that he was a problematic employee when it came to following a number of the rules that they imposed and just having good, employee characteristics, like showing up for work on time and things of that sort.
Staying in his room, was that a problem that you identified?
That he would leave the room unattended and not be there in violation of their rules.
So whether we're talking about the essay case or any of the 13 plaintiff's claims, as you look at the negligence theory, would you agree that there was a duty that was owed by the Olympia Early Learning Center as to each of the plaintiffs?
Objection calls for a legal conclusion.
Overruled. You may answer.
Well, I believe that there was a duty, yes, owed to each of the kids, and then a derivative duty owed to each of the parents based on Washington law, which recognizes a loss of consortium claim.
And remind us, was Eli Tabor hired in roughly 2007, 2008?
I thought it was 2008. I thought he was hired initially as a like, part-time or temporary employee, and then graduated to being a full-time employee a couple months later.
So what evidence did you gather that from 2008, really from the beginning of his employment through the point that he resigns, that there were concerns on a number of fronts about his employment?
That was true, that he was counseled and occasionally disciplined, and it was reflected in his performance evaluations that he was basically a deficient employee in several respects, including things like attendance, rule following and things of that sort.
Would it have been fair then to have, let me rephrase it. You said as to SA that you felt that there was evidence of breach, but would the evidence of regular employment discipline problems from 2008 forward have been a part of the body of evidence that all of the plaintiffs could have produced in proving breach of the deal?
And that would be a legal issue that would be determined by the court, whether, say, the fact that he did not come to work on time would be a red flag for him being a danger to sexually molest children, or him leaving the room when he wasn't supposed to, is that a red flag for a danger to molest children? What I focus on in the defense of this case and other cases would be things that are I think, more obvious red flags for a child molester. And I would have argued that things like coming into work late, or gossiping, or leaving the classroom when he wasn't supposed to, are certainly problems that management should deal with, but they aren't red flags for a sexual abuser.
Accurate though to say, or to again point out that the evidence of the breach that existed would cause Eli Tabor had been a problematic employee from really the beginning forward, that you didn't feel there was enough evidence in your favor to move for summary judgment.
On that issue, correct.
And by the way, no one from Philadelphia Indemnity ever directed you to file a summary judgment motion, right?
No.
And do you have cases where the insurance company adjuster or personnel are directing you to file summary judgment motions, or asking you to file summary judgment motions?
No, that's normally a more collaborative process, because summary judgment motions actually cost a fair amount to research and write and argue. And so it's more of a collaborative process where, what is the likelihood it will be granted versus the cost of actually, preparing, filing, and arguing it.
And who are the collaborators when you're talking about it's usually collaboration?
It's usually the claims adjuster.
With yourself?
Yes.
And I think you indicated that there's a discussion about whether there's a cost benefit to filing the summary judgment motion.
Yes, correct.
And you indicated because there's heavy costs or expenses associated with the summary judgment motion.
Right. It could easily cost $25,000 or $30,000 to do all the work necessary to file a summary judgment motion.
Did you collaborate in this case with the Philadelphia Indemnity Adjuster about summary judgment motion?
There was some discussion at the very beginning, and I think we saw an email about that yesterday, and I don't recall anything after that. But I haven't reviewed all the correspondence, but I don't recall anything.
You remember it being a collaborative decision not to bring summary judgment motions?
No. There was initial discussion of it. I just don't recall discussion after that point about, one of us raising the issue of what it would cost and what is the likelihood it would be granted, and the other one responding. So I just don't recall those conversations with Jackie Holloman.
Ultimately, there was just no summary judgment motions, right?
Correct. At the time that we entered the consent judgments, that's correct.
Which was September 14th of 2012.
I know it was mid-September.
September 14th.
Sorry, this is confusing. The last thing I have is I know it was maybe September.
That is correct.
I wanted to point out that I was incorrect. It's September 19th was the first, September 14th was a pretrial conference with Judge McPhee. So as to the defense theory, because there was no summary judgment motion, was the defense theory dependent on you persuading a jury that they should enter a defense verdict?
I guess ultimately that would be true in every case, but I would say that the theory for 5 of the 6, not including SA, is that there was not credible evidence that they were abused by Eli Tabor. And the defense theory with regard to SA, it was probably, my theory would be that it would be counterproductive to even put on a defense regarding liability, and it probably should be an admitted liability case focusing on damages.
So let me go through that for a second. So I heard you indicating for SA, it was your thought that should be an admitted liability case. Is that right?
That's what was going on in my head, having learned and developed, the facts about the red flags and things of that sort.
As to the other, I think that you acknowledged that the defense was dependent on presenting a case to the jury and persuading the jury that there should be no liability. Is that right?
Yes, although that's a strategy, I guess. I wouldn't characterize that as the theory. The theory is he did not abuse these 5 other plaintiffs, and the strategy would be to persuade the jury that there's just not enough evidence that any of them were abused.
So my question was aimed at your theory, your defense theory was dependent on you presenting at trial and persuading the jury at trial that you were right.
Correct, unless we did actually file a motion for summary judgment that was granted.
Which didn't happen in this case.
Which did not happen before the consent judgments, correct.
Right, which hadn't happened in over basically a year and a half of litigation in the Steele case.
Was it a year and a half?
Yeah.
Yeah, April, well, it would be, I first got involved at the end of May through September, so. Yeah.
And as you've now confirmed, there were no discussions between you and the adjusters about bringing summary judgment motions because you didn't feel that they were likely to win.
That is correct, that summary judgment motions in these types of cases, I considered after working on these types of cases for 20 years, were unlikely to prevail.
And so back to this point, if the defense theory was dependent on the defendants persuading the jury at trial, would you agree that that was made more difficult by a failure to prepare a defense for the case?
Well, what you say, fail to prepare a defense for the case. I don't agree with that I actually felt quite familiar with the facts and a lot of the witness testimony that if we went to trial in October of 2012, we would have had a defense to the case.
Well, let me ask about the specifics. As of mid-September 2012, had you taken a single deposition of the child plaintiffs in the case?
No, and for most of the child plaintiffs, I would not have taken their depositions.
Okay, I don't need to strike the non-responsive portion.
That's denied.
But Mr. Bolstein, I do want you'll get a chance, I'm sure, with Philadelphia indemnity lawyers to extrapolate on these answers. But I'm going to try to be very specific, and that's for the record down the road. Mr. Bolstein, as of mid-September 2012, have you taken a single deposition of any of the plaintiff's parents?
No.
Have you taken a single deposition of any of the plaintiff's experts as of mid-September 2012?
No.
Had you taken a single deposition of any lay witness of the case as of mid-September 2012?
I had not initiated depositions. I had actually attended some of the depositions that you noticed and questioned those witnesses.
So my question is this: had you yourself noted and conducted any depositions of any lay witnesses in the case?
Objection asked and answered.
Overruled.
I had not noted and taken depositions. I had questions of witnesses that you had noted.
Had you taken depositions of any of the plaintiff family members as of mid-September 2012?
No.
Had you taken the depositions of any witness at all in the Olympia Early Learning Center litigation as of mid-September 2012?
No.
Did any of your experts that had been identified in an expert disclosure provide you with any opinions as of September 2012?
I don't recall.
Do you remember having said in deposition that they had not prepared?
Well, they had not prepared reports. I don't know. I don't recall at this point whether I had had conversations with them where they gave me opinions about any particular issues.
Do you remember the aftermath of the consent judgments, that there were discussions, it's actually subpoenas to the experts, and it was learned that the experts that you had identified in disclosure had done zero work and had been provided no records?
Objection, Your Honor. These continue to be leading questions.
Well, that's not a leading question, so the objection is overruled. The question is, do you remember in the aftermath of the consent judgments that there were discussions and actually subpoenas to the experts, and it was learned that the experts you had identified in disclosure had done zero work and had been provided no records?
And the answer is I was not involved in that process, so no, I don't.
As of mid-September 2012, had you met with any experts in preparation for any supposed testimony at trial?
Not that I recall, no.
Would this have been the most unusual defense preparation of a case leading into a trial set 3 weeks later, roughly, ever in your career?
For a litigated case in trial, yes. For the other work that I do with labor, no.
But this was a litigated case, right? This was a case that you knew to have at least 7-figure exposure, at least from SA, if nothing else, right?
The leading questions, Your Honor.
It is a leading question. Sustained.
Had you evaluated the SA claim as being a case that had over 7-figure potential for it?
By over 7-figure, do you mean potentially over $1 million?
Yes.
Yes.
And so this would have been the only time in your career where you've gotten 3 weeks out from trial without having done any depositions that you conducted and without having experts prepared.
Yes.
Unusual, right?
Yes.
Mr. Bolsina, I've put 2 of the exhibit binders in front of you, and have you take a look at exhibit 14, which should be in the binder that you grabbed out. Permission, I'll show exhibit 14.
Yes.
Mr. Bolsina, this is actually kind of a housekeeping item. Do you recognize these notes that we see in exhibit 14?
I recognize my handwriting, so these are my notes.
All right. And when you see up top, this was apparently, well, you tell us what these are, if you would.
I have not seen these in 10 years, but they appear to be, I mean, I'm guessing from the way that they're structured here that it is a meeting or telephone call I had with Rose Horgdahl on August 3rd, 2011.
And I'll give you a moment to take a look at those.
Do you want me to look through all of them or just?
I can point out, I don't want to catch you unfairly if you haven't looked at them for a long time. Now, a couple spots where we probably need your interpretation of what the handwriting says.
Okay. My handwriting's better here than it is in most occasions, so sometimes I can't even read it myself.
Do you remember the interview with Rose Horgdahl?
I don't.
And just for the record here, can you tell us who Rose Horgdahl was?
She was the program director who reported to Steve Olson at OELC.
And do you recall whether she was ultimately a defendant in the case as well?
She was. You filed lawsuits, 3 lawsuits against her in May of 2012. So she was an individual defendant in those lawsuits.
In the very first sets of notes, tell us what you were finding out about a CPS investigation. It looks like.
This was a CPS investigation against Rose Horgdahl, I believe.
You got a chance to hear a little bit of testimony about that yesterday as to those.
Maybe, well, actually, it says founded for one, but not the other yet. CPS Tammy, interviewed by Tammy. I'm sorry,
That's all right.
I don't know what.
That's fine, Mr. Polson. We got to hear a little bit about it yesterday. Let me have you interpret this for us, make sure that we're reading this right. The part that I yellowed down here with the ND.
Yeah, it says left him unsupervised with ND, and I don't know what that refers to at this time.
Let me have you take a look at the next page. Spots that we wanted to get your handwriting analysis on. You'll see the highlighted portions. I'll go to the screen with the court's permission.
Yes.
Looks like essay is referenced here. Can you tell us what these words say?
Okay, it says found it, lack of supervision, not calling CPS in a timely manner when mother called and was upset, made sure that Eli quit.
Can you give us context on that?
This is where Rose Horgdahl is talking about a CPS investigation and a finding against her. And there were 2 prongs of it. One prong was that Amanda Myrick came in and told her about what Eli Tabor had done. She had placed a call to the Department of Early Learning, but did not call CPS or law enforcement within 48 hours, which is required by the statute. And so that was one finding against her.
Down here at the bottom, help us where it says, it looks like Eli not being supervised properly. Is that what that says?
That is what it says.
Let me turn to the next page.
Okay, I'm there.
Okay. So let's take a look at this part that I'm about ready to highlight here. You see this part where it says Corey and Libby or Libby?
Yes.
Can you read that for us?
It's Corey on top, Libby on bottom. Concerned with Eli showing favoritism, dash, taking him out at lunch, dash, contacted mother, it was fine.
And by the way, are these notes of information that you're gathering from Rose Horgdahl during this interview?
Yes. Well, I believe so.
So I'll highlight a couple more parts, Mr. Wilson. If you look up at the screen, that'll help me direct you. Would you read this section that we just highlighted?
Eli would leave his classroom on a regular basis, dash, not doing ECAP training / EDU, arrow, cannot follow ECAP procedures to stay in classroom.
Do you remember whether ECAP training had to do with child sexual abuse?
I don't.
I'm going to highlight this part down here. Can you read that for us?
Put him in infant room with infant teachers.
And would the infant room included, for example, 2-year-olds?
Yes, I believe that was the infant room would include 2-year-olds.
And in the infant room, 2-year-olds would have included minor plaintiff JT and SRB, right?
I believe so, yeah.
Let's go to the next page and have you tell us about a few other points. We've got a couple that you've seen highlights up on the screen. If you can read those for us.
Problems, still leaving the classroom. And then you also had leave early, not coming in at all.
And can you tell us whether these were part of the employment problems, or at least a small portion of the employment problems for Eli Tabor?
Right, these were issues that they had with him, yes.
Highlight one more portion. If you look at the screen, explain for us what this passage is all about.
It says, do you want me to read it first? May 2010, final probation, uproar with Cook, Sonia in middle of hallway, argument about him spending too much time with SA, was told to stay out of classroom, disruptive, SA would be upset after Eli left.
Let's keep reading on down, if you will.
Sonia yelled at him, he yelled at her. And this is one of those occasions where I can't read my handwriting. Something, exclamation point, screaming, exclamation point, profanity, exclamation point. Put Eli on final probation, messed up one more time, firing, put Sonia on probation for screaming, profanity.
And so as you are recording these notes, are you processing that in terms of problems with the defense theory, that there were notice and concerns about Eli's employment?
Yes. This actually, and I actually, Sonia was one of the OELC employees that I actually met with after I heard about this, because I wanted to get more information about this blow up between the two of them. And so this I thought was a red flag for potential sexual abuse in the ways that, like, coming in late, leaving early, not staying in his classroom were not.
Let's go to the next page. Highlight this top sentence, if you could read that for us.
It says should be in his file.
Did that mean that the reprimand should have been in his file, or the probation should have been in his file?
I don't know what I was referring to there.
Did you learn evidence that there were concerns by employees at OELC that there were missing records from employment files such as Eli Tabor's?
Yes, I actually, when I got the CPS investigation file, there was one document in particular that several of the teachers had accused Rose of removing from the file before it was produced to CPS.
And was that a cause for concern in terms of developing the defense theory?
For SA, yes.
Would it have been more generally a cause for concern in terms of relying on Rose Horgdahl's credibility or the management of OELC's credibility?
Well, with Rose Horgdahl, yes.
Let's have you read this part, if you would, that I'm highlighting right now.
People raise concerns about them being too close.
And then how about I just have you read the rest of that?
Taking on too much responsibility, calling him Daddy Eli. Mom is okay with it.
Turn to the next section here. You read that for us.
Plenty of write-ups regarding Eli's communication before the Sonia argument.
Okay, help us understand what that means.
I'm relying upon my memory, which may be defective, but there was a lot of drama at the OELC among the teachers, and Eli would get into spats and disputes with other teachers where intemperate language was used.
The plenty of write-ups regarding Eli's communication before Sonia's involvement with Gunman meant that if Sonia's blow-up happened in May of 2010, that there were lots of situations before Eli had been written up.
That's what this statement suggests. That's what Rose communicated to me, that there were lots of disputes and issues between him and his fellow employees.
We highlight this portion in the July 2010 segment. If you could read that for us.
Just the highlighted portion.
Yes, please.
July 2010, wanted to terminate Eli.
And is it reasonable to infer that that means that Rose Hordahl wanted to terminate Eli
Yes.
in July of 2010?
Yes. I actually recall that in addition to what's in my notes.
And would that have been roughly 6 months before he resigned?
He resigned in January of 2011. So yes, I get.
Next page on top. You can read that first line that I'll highlight.
Going to terminate him.
Was that, again, is it reasonable to infer that that's Rose Hordahl who's going to do that?
Yes.
We have to read this next section down here, which looks like it starts with Steve.
Steve overruled termination, back on probation.
Again, as you're hearing this information, were you processing concerns with how the defense theory would play out given this type of evidence?
No, I mean, this information about him violating the rules and them about to terminate him and then putting him back on probation, that I didn't consider particularly significant to the liability issue. The issue we talked about before with Sonia, the cook, that I did.
Did you consider how the plaintiffs might use the fact that there was one program director who was wanting to terminate him and another director who overruled it, put him back on probation?
If the reason why he was being considered for termination did not have to do with his relationship with SA, it had to do with other instances of coworker issues and attendance issues and following rules issues. And just, I mean, I'm primarily a labor and employment attorney, and this is the kind of thing I see, every day, 8 hours a day, and 99.99% of the time, issues like this are being dealt with outside the context of sexual abuse. So in my mind, I'm not processing this performance management as a potential red flag for sexual abuse.
Because most of your experience has been in the employment realm where this might not be, right?
Objection, pleading.
Right, where it's in the context of, I'm sorry.
It's a leading question.
Can you tell us whether the reason why it was less significant for you, at least as you processed it, was that you saw this regularly in the employment arena?
Correct. Outside the context of this person is potentially a sexual abuser. So I was looking to see what red flags existed that he was a danger to children, as opposed to an immature, undisciplined employee.
In terms of causation in this negligence case or negligent retention of an employee, did you consider that would be used by the plaintiffs as saying that he should have been terminated long before certain abuse events happened?
Yeah, that would be, I think, an argument that we would probably be discussing in prior to trial as to whether that evidence was sufficiently relevant or unduly prejudicial to the red flag. And I guess it's a somewhat of a proximate cause argument as to, can you say, well, if he would have been terminated for attendance problems, then he wouldn't have been around in order to, molest SA later. I'm not familiar with how that argument actually plays out.
For example, in the Department of Correction and Parole Supervision cases or the DSHS cases, is it fair to say that you just didn't have a whole lot of experience in the causation issues there?
I've never done those DSHS cases and stuff like that. So I don't know.
In terms of the Steve that's referenced up there where it says overrules termination back in probation, was that Steve Olson?
That is
Who was I guess the head of director of OELC,
executive director. Yes.
who became a defendant in the case, right?
In May of 2012. Yes.
Did you gather evidence from interviews with Olympia Early Learning Center witnesses that expressed concerns about the management efforts of Steve Olson?
Yes.
Tell us about those.
There were concerns, and this was yesterday. We looked at an email where I met with the head of the board, and at that interview, he basically told me that he had concerns that Steve was being inattentive, that he basically was sitting in his office and not really minding the store, and there were a couple other people who actually had the same comments about his performance.
Can you tell us whether that the concerns that were expressed, even specifically, were that he typically played solitaire all day long?
I'm sorry, I don't recall that level of specificity as to what they were speculating he was doing.
But in terms of the management concerns that were expressed by the board of director for OELC and the employees that you mentioned, did you cross that as concerns again with the defense theory?
Yes, in particular with SA, that as the executive director, that the jury would likely want him to have followed up on the red flags that some of the employees said that they had brought to management's attention.
Let me have you turn to Exhibit 3, and you got permission, I'll move it down.
Yes.
Well, so let me give you a chance to orient to this document. On the screen, we're looking at page 1, but I'm hoping that you can at least give a brief glance to all the pages and tell us what this document is.
Don't know what this document is. Is this? I suspect it might be Peter Altman's notes of witness interviews, or they might be mine.
Likely that it's Summit Law Group's interview notes.
I have not seen this document.
Do you have your computer file here or anything to verify that? Unless it's stipulated by the Philadelphia codes.
I don't think these are my notes. They might be Peter Altman's notes of witness interviews.
Tell us about who Peter Altman was.
He was an mid-level associate employee that I brought over with me to Summit when I came in 2011. He helped me on this case during its pendency.
All right.
And one of the things I asked him to do was to do interviews with OELC employees and former employees.
Is it likely that you reviewed these notes back when you were working on the case?
It is, but they didn't stick in my memory enough that I actually recall them today.
And let me phrase it this way. Was there a point at which that you directed Peter Altman in the work on the Olympia Early Learning Center case to go and interview OELC employees?
Yeah, well, direct is not really a Summit way of doing things, but yes. We ask politely.
What was the purpose of that for doing those interviews?
To basically uncover, facts that would be relevant to the lawsuit and the defense of it. Getting the perspective of the testimony of former and current employees, and also getting a sense from Peter about them as witnesses.
And will tell us whether part of the reason for conducting these interviews was to understand the strength of the defense theory and the strength of the plaintiff's theory.
Yes, of course.
Let me have you turn over to, if you see it up on the top, if you look up here, you're going to see page numbers. Let's go to
I do.
Page 75. And we'll take a look at the notes that were gathered from Dory Gore. See if any of this information rings a bell. You look at this highlighted portion.
I would say that this particular information from Dory Gore does not ring a bell, but hearing from Peter and reviewing the CPS file, I recall that there were several teachers or former teachers who had very critical testimony about Rose Horgdahl, both generally and with respect to essay.
And can you tell us whether that would cause a problem with typical defense theory and presentation at trial, having that type of situation?
Well, I thought that it contributed to making the essay case an admitted liability case because, teachers testifying that, hey, we brought these red flags to Rose Horgdahl and Rose Horgdahl did nothing. I thought that I didn't know of a way to actually effectively cross-examine that.
And I appreciate you pointing out essay, but can you tell us whether there was any basis for this? Well, let me put it this way: did you consider whether this same type of evidence, the criticisms of Rose Horgdahl and Steve Olson, would apply to each and every one of the plaintiff's cases?
I think that's a matter of argument, but again, I was focusing on with those other cases whether they had been abused at all. And Rose's management of OELC or Steve's management of OELC didn't seem highly relevant to the question of whether they were abuse victims to begin with.
Is it fair to say that you were essentially conceding duty and breach for all of the plaintiffs, given what you had gathered from the interviews of the OELC folks?
No.
Let's take a look at Dory Gore's specific information that she conveyed to Peter Altman from your office. You see, let's see, this part right here where it says, feels like both Renee and Rose should be in jail. You see that?
Where? I'm sorry, Mr. Cochran, can you show me where you're looking?
Yep. Right. You have this relationship section, and then 2 lines up, it says, feels like both.
Oh, I see it now. Thank you.
And that was Rose Horgdahl, right, your client?
Correct.
And Renee Day was a person immediately under her in the supervisory chain. Is that right?
That's my memory, yes.
Dory Gore went on to list a variety of issues that she was concerned about with both Renee and Rose Horgdahl, right?
Yes.
Including some credibility issues with both Renee and Rose, right?
Yes.
Missing files about the napping citation were an issue for Ms. Gore, right?
Based on a rumor she heard, yes.
There were concerns rampant within OELC employees. Let me put it this way. Did you gather evidence from the interviews about concerns with other program directors like Beata Harris?
Yes.
And what were the concerns that were raised by co-employees?
I know that there were concerns about Beata Harris. I don't recall what they were. I do recall one employee saying that she had complained to Beata Harris about her concerns about the relationship between Eli Tabor and SA, and Beata Harris responded in an inappropriate fashion, but I don't recall the details of what that was.
Was there a point at which Eli Tabor was arrested for a DUI in 2010?
Yes.
I remember whether Beata Harris was the person who was assigned for OELC to assist him in counseling as a result of the DUI?
No, I don't recall that.
Do you remember there being concerns by employees that she failed Eli Tabor because of her own insobriety?
No, I don't recall that.
Do you know whether they're in these notes, actually?
They might be.
Let me point you to, by the way, Dory Gore was an employee from November of 2007 through July 2011, right?
That's what I think are Peter Altman's notes say.
And did you process the fact that the evidence that Ms. Gore was providing was basically covering the entire time in which the plaintiffs were all at the Olympia Early Learning Center?
I don't know if I thought that or not at the time.
So can we have you take a look at the next page? As to Renee Day, you see the notes. Did you talk to Peter Altman about his inclusion in the notes of Renee Day also criminally liable for cover-up and what he meant by that?
I understood that to mean that that was Dory Gore's opinion, and I don't recall specific discussions with Peter Altman about particular parts of these notes.
And again, as you're developing your defense theory through these interviews, did you formulate concerns about the fact that some of the employees felt that there had been a cover-up as to Eli Tabor and what he'd been doing with children there?
I had concerns that there was a cover-up about what Eli Tabor was doing with SA there. I don't recall having any testimony or concerns about the other children who are plaintiffs, or the other children at the OELC.
In understanding that you might have been focused on SA, did you take the notes that Peter Altman had generated and apply it to all of the other plaintiffs who were at the OELC during the time that employees like Renee Gore or Dory Gore were?
And I would say that I was focused on SA because that's what all these witnesses were focused on as well. Typically was issues with regard to Eli Tabor and SA. And the answer is no. I saw that the other cases had different issues entirely, that being, were they even one of his victims?
But was there anything specific about the employees' concerns, for example, with Steve Olson not involved playing solitaire all day, that was limited to SA as opposed to being applicable to every single plaintiff in the case?
Objection leading.
Yes, because
Overruled, you can answer.
I saw the issue being different in the 5 other cases because I didn't see the credible evidence that any of them had been abused. So whether Steve Olson was playing solitaire rather than, doing a better job of running a daycare didn't change in my mind whether there was credible evidence that all those other people had been abused.
So
It did create a concern in my mind with regard to SA because he was a known victim of Eli Tabor's abuse.
So Mr. Bolson, that's what I want to make sure that we have clear on that. When we talk about duty and breach, we're talking about one, did OELC have a duty to these children, all of the children, you acknowledged yes. And then we talk about breach, and you understand that the plaintiff's negligence claims included negligent failure to supervise, negligent failure to implement policies, all of which apply to every single one of the plaintiffs.
I did understand that, but unless they were molested, it didn't mean anything. The fact that he was, they were not supervising Eli that doesn't provide every kid at OELC a cause of action unless he molested them too.
And so now I want to drill down. So this is what I asked you earlier. Was your focus almost singularly for all of the other plaintiffs other than SA simply on whether the abuse had happened, as opposed to whether there was evidence of breach of duties?
Yes, because without the abuse happening, I don't think that there was no claim here that they didn't get, good care at OELC because, Eli wasn't a good employee. These lawsuits were all about, allegations that children were molested. And so that's why I considered SA to be, one type of case, which was a substantial liability, substantial damages case, and the other cases where there were serious issues, even getting past, whether they were abused or not.
I understand that was your theory. By the way, that belief that had embedded in you about whether the abuse had happened with any other kids was primarily your apprehension that Eli didn't access the children at it. Am I right about that?
Objection, leading.
It's sustained.
Can you tell us whether the belief that you had that Eli Tabor did not abuse the other kids was based on a belief that he did not have access to children, the other children?
That was the concern about JT and SRB. With AK, MM, and JJ, it wasn't the same concern.
Because he did have access to JJ, MM, and AK?
Definitely with MM and JJ, and I'm having memory issues with AK. But there were again, the access issue around the time that the disclosures were made. That was my focus with JT and SRB. The other three cases were basically two of them. I was not aware of any disclosure by the child of sexual abuse. And with AK, my issue was, yes, there was a disclosure of sexual abuse, but it was after the mother based the claim on behavioral only, and then was told by the caseworker that they needed disclosures in order to pursue it, and then all of a sudden there were disclosures. So it was different based on who the plaintiff was.
Mr. Bolsian, did Eli Tabor admit sexually assaulting the boy ND in 2008 when that not only happened but was discovered at OELC?
There were suspicions that ND was molested. I don't think that there were any accusations made.
My question is, did Eli Tabor admit that he sexually assaulted the boy ND at OELC when that occurred back in 2000?
No.
He only later admitted that during criminal prosecution in 2011, right?
That's correct.
Did the boy ND make a disclosure when Eli Tabor sexually assaulted him in 2008?
No.
By the way, were there concerns expressed by OELC employees that there were other victims who weren't even identified in either the plaintiff's suits or the criminal investigation?
I don't recall that from the CPS records or the law enforcement records or from my interviews.
Let me have you turn over to page 77. Remember, Mr. Altman there somewhat while gathering information from employees about a boy named Carmine Lester.
No, I don't remember this testimony.
And then Mr. Altman, who was working with you on the case, gathered evidence from employees that molestation with Lester could be possible.
Objection, leading.
Well, The objection is sustained because it's beyond the knowledge of this witness. The witness has testified that he has no information about this alleged statements either directly or via Mr. Altman. If I'm misstating the witness's testimony, somebody can correct me.
I wouldn't say that there is a blanket. I don't remember anything in these notes, but it's been a long time since I've seen them and a long time since I've reviewed this case. This does not step out at me, but this is also not significant to me.
And appreciate that. I just want to make sure that the court is comfortable, Mr. Bolasina, that you are convinced that that Exhibit 3 is a set of notes that is generated by your office in representing police.
Yes, when I initially looked at them, I didn't know, but the more I looked through them, these appear to be Peter Altman's notes of witness interviews.
And I want to take us back to the very first page of these notes, Mr. Bolasina, and I'm just going to walk through a couple of key points. Down at the bottom of the very first page.
Okay.
This was the employee Aisha Johnston you see up on top.
Yes.
Okay, and
I'm not sure where we are. It's not showing up.
yeah. So down here where I highlighted, and Mr. Bolasina, you'll be able to see the record itself.
Mm-hmm.
That last paragraph, can you read that for us?
Had known Beata Davis since she was 8-9, played soccer with her daughter, nice person, very strict, very helpful. She left OELC because of a drinking problem. She needed to go to AA meetings to stay at OELC, but she refused.
Do you remember that type of evidence having been gathered by your office regarding Beata Davis?
That does ring a bell that Beata Davis was accused of having a drinking problem.
Did you follow up, or did Peter Altman follow up with Beata Harris about whether Beata Davis / Harris as to whether there were conditions placed on her employment regarding her sobriety that she failed?
If we did, I don't recall them at this time.
We see here in this particular employee comments about resentment toward Rose. She did not always give parents information, and Rose also disliked Eli. Did you see that?
I do.
And did you gather information, or did Peter Altman gather information about the concerns employees had levied about a change in Rose Horndal's approach to Eli, from one where she was very concerned about his employment conduct and behavior, to essentially protecting Eli from criticism?
No. Were there teachers who thought that Rose was protective of Eli? I believe that there were.
Specifically, I'm wondering if you remember whether there was evidence gathered that employees felt that Eli had obtained some sort of dirt on Rose that he was using to protect himself from termination.
I do recall that there were teachers that had speculated about that.
So let me actually have you take a look at the second page. This employee Johnston. Let me highlight this portion down here. Starting with Emily Torres may have seen warning signs. You see that?
Yes.
And then the next paragraph that said Rose did not take action. An internal report went missing, made employees angry. You see that?
Yes.
And then the next sentence, she heard a rumor that Eli had some substantial dirt on Rose, which kept her in check. You see that?
I did see that, yes.
And by the way, did you discuss with Philadelphia Indemnity in emails or phone calls. The fact that this dissension between the employees and the administrators was going to be problematic at trial.
What do you mean by dissension?
Employees who are expressing concerns and misgivings about the ability and credibility of the management of OELC.
In particular with Rose Horgdahl, yes.
I wanted to point out one other part here on this second page, page 68, where it talks about Eli's job sites. Do you see that up there?
I do.
And tell us about the job sites that Peter Altman learned about from this particular employee.
It says sunflowers, then half pints. He was assigned to many rooms. As a substitute, he was in many rooms. As an assistant, teach with the sunflowers, then the rosebud wobblers, and then the half pints.
Sunflowers,
Then the rosebud / wobblers, and then the half pints.
go to the next page. I'll highlight this section. Here, we talked earlier about whether there were multiple potential victims that were not identified in either the lawsuits or the police investigation. You see this section that Peter Altman had gathered from the employee about an employee named Emily accusing Eli of molesting SA.
Yes, I see that.
And she alleged that Eli had a picture of SA or another young naked child on his phone.
Yes, I see that.
And did your office do any follow-up with this employee, Emily Torres?
I don't recall whether she consented to being interviewed with Peter or not.
Did you feel like that would have been an important part of the puzzle to understand what Emily Torres had to say?
I understood that she was critical of Rose and OELC, and I saw the interview that she gave to CPS on those issues.
And did you undertake to take her deposition at any point?
No.
Right underneath that section, you see that Eli's DUI. Do you see that section?
Yes.
By the way, Peter Altman down here learns evidence from the co-employees about Eli Tabor hanging photos of SA all over his office walls, right?
Yes, I see that.
And did you consider how the jury might think about that if the case was presented at trial?
I thought that would be another red flag that he had an inappropriate sexual relationship with SA. Yes.
Did you and or your office gather information from employee interviews that indicated many people at the OELC were concerned about Eli attempting to move in with Amanda Myrick and her son SA?
After he was arrested, yes, I did see expressed concerns about him moving in with Amanda Myrick, including from Rose.
Did the employees that Peter Altman interviewed actually indicate that they had all discussed that at the time that was being considered?
I don't recall that.
Didn't Rose Horgdahl actually tell you that she was adamantly against Eli moving in with Amanda Myrick?
Yes, she said that she was against it.
At the time, not later after an investigation.
Correct. At the time, she said that she was opposed to him moving in with her.
On page 70 of Exhibit 3, you see this top part that everyone thought Eli moving in with Amanda, but with Myrick was a bad idea. It was commonly known. Eli lived with Myrick for a year until his arrest. See that?
Yes.
You had mentioned earlier in testimony you couldn't remember whether Eli was a teacher of AK, known as junior. Let me direct your attention to the middle of this page. See where it says Eli was junior's teacher?
Which page are you on? Is it 70?
Yes. I highlighted it here.
Oh, okay. Oh, Eli was Junior's teacher, yes.
Can you turn to the next page? Under the Alicia Mendoza section. See the section confirming, at least from this employee, that Eli took care of MM?
Yes.
Let's go over to page 73. We have an employee named Angelina Thayer. Do you remember her?
No, I don't. I mean, no, I don't.
Start us here. This is Peter Altman's gathering the information from Ms. Thayer, saying she had heard that one write-up went missing, which is what you had understood as well. Is that right?
Yes.
And did you gather that information from looking at the CPS file?
Yes, but actually, Rose, I interviewed Rose about that particular document, and I do recall that as well.
Ms. Thayer provides Peter Altman the information about Eli being inappropriate with SA laying with him, possibly kissing on the lips, and that this was the subject of the write-up. Is that what you gathered as well?
Yes, I mean I've seen that write-up, so this generally describes what it's about.
And process of this witness was another one of the witnesses who was going to be talking about the West Side OELC Center being very poorly run, and that there were concerns with the credibility and conduct of people like Renee, who is one of the supervisors at OELC.
Seeing the notes from Angela Thayer, the ones that Peter Altman took, it appears that she was critical about OELC's operation.
Over on page 76. Employee is indicating that this is Ms. Gore. Looks at red light behavior of Eli Tabor.
Is this Ms. Gore?
In this note, she is indicating that there were red light behaviors of Eli Tabor. Is that what you see as well? Mr. Wall, see that?
Yes, she's saying that she describes red light behavior with SA.
By the way, in terms of accessing kids in all of the various rooms of OELC, you see Ms. Gore confiding to Peter Altman that Eli Tabor worked in all of the rooms for at least a short time.
Yeah, I believe that's true. That particularly when he was a floater at the beginning of his employment, he was placed in different rooms.
You see the section where Ms. Gore indicates that she was instructed not to talk about Eli or SA or else you'd be fired. Told it was all gossip.
Yes, I see that.
And that Rose gave the directive.
Yes.
If you process whether or how that would be received by a jury in the event that this was presented to the jury.
Yes, that would. I mean, if they believe that happened, that would not make OELC or Rose look good in front of a jury.
I'm going to turn over to page 80. Colleen Moore, do you recognize that name as being one of the people who was brought in for a short period of time to be a supervisor?
Not at this point, no, I don't recognize that.
And you remember processing the information about Ms. Moore's statements, Peter Altman, that OELC was a very poor facility, did not want people keeping their children there.
No, I don't have any specific memory of Peter's conversation with Colleen Moore. Is there some place? Oh,
On page 80, up on top.
yeah, I see that. That's based on Peter's notes. What I believed that she told him when he interviewed with her.
Right. And Ms. Walton, this is information that you would have been reading back at the time, back in the fall of 2011, as you were representing OELC, right?
Yes.
And so my question is, for example, when Ms. Moore says that she stopped promoting OELC when she learned how terrible it was, were you considering how that might be received by a jury on all of the plaintiff's cases?
Well, again, these are all subject to relevance and unduly prejudicial. And it seems that you believe your case can be made on this was not a well-run facility, and my defense would be that a lot of the complaints that these employees had about how it was run, to the extent that they have to do with Eli Tabor being a risk to children, that's relevant. To the extent that their concerns are about other things, that may not ever reach the jury.
Right. You would have had to go and study the cases on negligent supervision of people with dangerous propensities to understand how that might have played out in the court, right?
Objection, lady.
Would you agree?
I'll overrule the objection.
Yeah, I believe that, for example, if one of the employees has a drinking problem, unless you can somehow connect that to the sexual abuse of a child, then it seems to be irrelevant and unduly prejudicial to me. And there's plenty here. There's plenty here about red flags about his relationship with SA, but there's also plenty here that is just basically the gripes and beefs of a lot of dissatisfied former employees, and I wanted to try to keep that in some perspective.
Do you recall there actually being employees who indicated that the sobriety of Ms. Beata Harris was a condition of her employment at OELC because it caused problems?
I don't recall. It may be, but I just don't recall that detail.
In fact, isn't Colleen Moore's employment predicated on the fact that Beata drank heavily, and that's why she was brought in? That was understood by people at OELC.
This is a detail that I don't recall 10 years later.
Let's go to page 81.
Which page?
81. This is another employee, or this is still more red flags concerning Eli's behavior. You see the section down here, which she's indicating that it was well known that Eli was laying down with employees, or not with employees, with children at OELC.
Yes, it says, she just thought he was lazy around, plenty of other staff and students around, so not very concerning. Several times Eli would be halfway laying down, propped up on his forearm.
Next page. Understanding that these are all prefaced by Mr. Altman with rumors, I think you'll acknowledge that that your firm did not interview all of the employees at OELC, right?
That is my memory, yes.
Right. In fact, there are employees like Emily Torres, Angie Vasquez, and Corey Giroux, who you specifically neither interviewed nor deposed, right?
I don't know, but if we interviewed them, there would likely be notes about it. I know we did not depose them.
Okay. On the next page there, on page 82, you see the information about Peter Altman gathering that Eli would be cuddling under the blanket at OELC with SA.
Yes.
And you had mentioned yesterday that you knew that the standard of care at a daycare was certainly to have two people at all times in a room. Did you also recognize that the standard of care was not to allow employees to be cuddling under blankets with the children?
I would agree with that, yes.
Let's take a break, please. It's 10:20. Court's going to take its mid-morning recess until, it's now 10:21. We'll be in recess until 10:41. Thank you.
Rise. Court is now in recess.
Ten 10:41. 10:41. Okay, thank you.
Yeah. Very difficult today.
Again,
Even,
worse than yesterday.
yes.
Maybe it's,
I actually, my notes are really clean from yesterday afternoon.
I was trying to gotten back from dinner and I had to restart my computer. And I was like, oh, okay, I didn't recognize that this is.
I had a meeting. My room had no lights. It took them about 20 minutes to figure out how to get the lights in. I think guess what the end of the door. I don't know. First he switched, he checked the breaker, then he checked the PFI switch in the bathroom. And then he went away for 10 minutes and the lights stopped. I just got it. I was doing something. Oh, maybe a switch something.
All rise. Court is in session.
Please be seated. Thank you. Mr. Cochran, you may continue.
Well, see, we're still back on exhibit 3. I'm going to have us turn over to page 83 of this document, which is still within the notes that Peter Altman took with Colleen Moore. So I'm going to direct your attention to the middle of that page. Where it's talking about Rose Hordahl and CPS, and you'll see the section that says Rose started calling CPS and making claims against parents as retaliation. She called CPS about Amanda. More witnesses, Rose calling parents from downtown location, retaliation for complaints against the center. You see that?
I do.
And did you evaluate the potential damage to the defense theory it was seeking to present at trial, given this kind of retaliatory nature that some of the employees were prepared to testify about with respect to Rose Hordahl?
No, I don't. I actually don't recall in the CPS files seeing anything to support that Rose was retaliating against them by calling CPS.
My question is, did you consider the significance of the employees testifying about this at trial in the event that you were there presenting your theory of the defense at trial?
Objection asked and answered, lack of foundation.
Overruled.
No, I did not. Without corroborating evidence, and Peter was basically just collecting anything that the witnesses had to say, regardless of its reliability or factual veracity. And I couldn't basically go down every rabbit hole that any former teacher basically gave to Peter during the interview. And if I had seen evidence of this in the CPS files, then that would have caused me concern, but I don't remember seeing it.
I'm not sure what the CPS file has to do with the witnesses who were available for trial. So let me understand this. Did you go and take the deposition of Colleen Moore once you received the notes from Peter Altman about her statements that Rose Hordahl started retaliating against parents and accusing them of various things like abuse?
No.
Was that unusual in your experience as a trial lawyer in a case where you were going to go in and present Rose Hordahl as the bulwark, or at least one of the bulwarks of your defense theory?
No, I mean, if I had seen evidence that corroborated this allegation in the CPS file, but otherwise it's basically just an unsubstantiated rumor that it happened. And I would expect if Rose Hordahl was calling CPS and accusing parents of abuse, that CPS would have some record of those calls.
What does the CPS file have to do with the trial of this case? I don't understand.
I think it has everything to do with the trial of this case, because CPS investigated, 4 of the allegations in this case. And so I think that the CPS file and what the CPS investigators have to say about their investigations is highly relevant.
So were you planning on, well, let me ask it this way. Did you depose any of the CPS investigators?
I did not.
Did you plan on introducing the entire CPS file at trial with the 2 founded violations against Rose Hordahl?
Well, I assume that those would come in connection with at least the SA case if we were contesting liability.
Were you planning on presenting the CPS file somehow after I had brought up 10 to 15 employees from the Olympia Early Learning Center with their testimony about having the concerns that they did with Rose Fordahl and the other administrators.
Objection, Your Honor. Now Mr. Cochran is testifying as to what he did in the case, and I think we have a very clear ruling on that.
The objection is sustained.
I'll read it.
Okay.
But Mr. Bolsina, to get to your defense, which you're now telling us was a big part of it was the CPS file, you understood that that would have been after the plaintiffs had presented their case, right?
Possibly, it could also, it could also come in cross-examination if the documents were admitted prior to that.
But would you have expected to bring in the CPS file in cross-examining Colleen Moore, for example, or Dory Gore, or Shiante Brown, or Sonia Clifton?
You are asking me about basically very specific information about a case that I worked on 10 years ago. So I haven't really given any thought to that issue in probably, the last 9 or 10 years.
But importantly for here, did you give thought to that at the time as you're developing the defense theory on all of the plaintiff's cases, not just SA?
I do recall that I thought that the CPS file was a critical piece of evidence in JT, SRB, and AK. Because again, those allegations were investigated very close in time to when the allegations occurred. And I thought what was done and what was uncovered as part of those investigations was something that the jury really needed to hear. The SA file, I thought, the CPS file would be very, damaging to OELC and to Rose Fordahl. And that contributed to my opinion that case was not defensible on liability.
Did you have any expert who had been paid a single dollar by Philadelphia Indemnity to present either the CPS file or any of the theory that you had about the abuse didn't happen?
Back to the form of the question, it's a leading question.
The answer is, I'm sorry.
That's okay. Objection is overruled. You may answer.
The answer is no. I did not hire an expert to present the CPS file.
Right. And so, did you have awareness that the plaintiffs had identified multiple liability experts to testify about their theory that the abuse had happened?
No, and I don't think that's a proper subject for expert testimony.
Were you aware, for example, that Dr. Matt Logan had been identified as an expert who would testify about the level of deviance by Eli Tabor, the opportunistic predatory behavior by Eli Tabor, the access that he had to these children, and the potential for his abusing the children?
I did receive a report from you from that expert. I don't recall in detail what that report said. I do recall that it raised the issue of the polygraphy exam.
Did you have your own expert to counter the impact of Dr. Matt Logan at trial?
No, and I disagree that is the subject of expert testimony.
I appreciate that. That would have been something you would have had to try to play out at trial. Is that right?
Right. The thing is I just don't see how that's the subject of expert testimony. It seems like the subject of lay witness testimony when people who were present in the classrooms with JT and SRB would say things like, Eli Tabor wasn't in the classroom that day and he had no contact with his child before this disclosure was made. And I guess you could call an expert witness who will say, disregard that. because I think that she was abused. And I guess I would cross-examine the expert then about, issues of childhood memory and 2-year-olds and what they're capable of understanding and communicating and things of that sort.
All of which would have been dependent on your preparation for trial, right?
Well, yeah, before I would cross-examine an expert, I would tend to prepare for that cross-examination.
You yourself, in collaboration with Philadelphia, did not have a single damages expert prepared for trial.
Objection, Your Honor.
Not if the case is, oh, sorry.
This is just an obvious attempt to, pin something on Philadelphia. It's not a proper question. I don't object to the question to the extent it's asking the question without the reference to Philadelphia in there. It's just improper.
Okay, will you rephrase your, the objection is sustained. Mr. Cochran, please rephrase.
Mr. Bolsina, can you tell us whether the defense had a single damages expert prepared to testify at trial in mid-September of 2012?
No.
By the way, with a defense like yours, which I'm hearing you say, I didn't believe that any children were sexually abused by Eli Tabor, would it have been important to understand through a deposition what the plaintiff parents had to say about the behaviors, the sexualized behaviors of the children?
Possibly, but without reliable disclosures of the abuse, I think that's of limited utility.
And I understand your narrative, but let me be real precise on the record. Would it typically have been expected in a defense of a case of this nature to have deposed the plaintiff parents to understand if there were sexualized behaviors of their children, if your primary defense theory was going to be that no abuse ever happened?
Yes, it would be helpful.
Right. I mean, your clients, and you tell me whether this is true, your clients, OELC, Steve Olson, and Rose Hordoff, had the right to expect you or the defense to have deposed the plaintiff's parents to understand whether they observed sexualized, unusual behavior by their children, if the defense was the abuses never happened to most of these kids, right?
Yes.
In terms of your statement that the employees, at least you thought apparently, were going to testify that Eli Tabor never had access to any of these kids or some of these kids, it brings me back to Exhibit 3. Because isn't it true that in the employee interviews, Peter Altman learned from employees that indeed Eli Tabor was in every single room of every single one of these plaintiff children with access and opportunity?
At some point in time, for example, JT was in his classroom probably months before she made the statement that her parents interpreted as a disclosure of abuse. And with a 2-year-old child, that's not the way I understand a 2-year-old's brain functions, is that they can tell their parent, hey, 6 months ago, Eli did this to me. So anything that they're disclosing really has to be very near in time to what happened for it to have any credibility whatsoever. So in sum, I'm saying that yes, if she was in Eli's classroom 6 months before, that really isn't an indication of, that abuse occurred at any point in time. If she makes a statement in February of 2009 when she was in his classroom a year before.
Well, I guess I need to separate out from the record, kind of your own individualized reactions to things versus what was prepared to be presented at trial. So let me ask you this. Understanding that you individually felt that way, did the defense, with you as its lead, have any experts prepared in mid-September 2012 to present evidence to a jury indicating that there was no evidence to support abuse.
I think that's a factual issue.
My question is, did you have any experts ready to prepared to testify at trial about your defensive theory that the abuse did not happen?
As I've answered before, no.
And did you have any expert testimony prepared about the issue of whether young children will disclose or not disclose abuse?
Not as I understand your question, no.
In fact, there would have been evidence, factual evidence from witnesses that a boy where there was a conviction, ND, had not disclosed, even though the abuse happened right there at OELC, right?
That's true, but I don't see how that's relevant.
Well, because, well, let me ask you, if your theory was that the children didn't disclose, therefore nothing happened, then how are you going to reconcile that with the fact that ND was abused and we knew as a matter of conviction, and yet never disclosed?
I just think it's a very weak case to say that he molested this child, he had access to this other child, and therefore this other child was abused as well. And I think that that's, 3, if not 5 of your 6 plaintiffs. And that's how I viewed this situation.
Appreciating that was your individualized feeling about that. Did you have any experts prepared to say, ladies and gentlemen of the jury, please disregard the fact that there was ND who was sexually abused, and we know this by admission and by conviction, and he didn't disclose, and that's the same or different than the other children.
Objection asked and answered.
Overruled.
Well, I think that 2 of the children were old enough, if they had been molested, they could have disclosed. That would be MM and JJ.
Can I need to answer my question?
Okay.
My question is, if you just testified, I thought it was personally weak that ND didn't disclose, and how would that relate to the others? My question is, did you have an expert in child sexual abuse who was prepared to testify that the jury shouldn't consider ND and his non-disclosure in considering the other children and their non-disclosure?
No.
You didn't have a child sexual abuse expert prepared in mid-September of 2012 to testify about any of these issues as to the nature or the likelihood of sexual abuse.
Objection argumentative.
It's been asked and answered, sustained.
Let's continue through Exhibit 3. I need to go to page 86. Down on the bottom, I think we're still in Colleen Moore's testimony. Nope, we're in Hannah Gore's testimony. You recognize that name as an employee?
I don't.
On the bottom of the notes on page 86 that Mr. Altman took, you'll see the red flags of Eli's behavior. And can you read those for us?
I do.
Okay. There was red flags about Eli and essay. Everybody suspected, but everybody thought nothing was actually happening. And you see down on the bottom where it says he would come into the classroom when he wasn't assigned to.
Yes.
And you understood that as being a problem throughout his employment, right?
I understood the problem that he would leave his classroom. I also understood the problem that he would visit SA's classroom when he wasn't assigned to it. So that's what I understood that to mean.
So the next page, 87, is where we're looking at more of the red flags. Ms. Gore apparently saw the kiss on it's described as the head here. You see that?
Yes.
And you understand that to be Eli Tabor kissing SA.
That's my understanding of what that comment means.
You see that Mr. Altman was learning that multiple employees, including Corey Giroux and Emily Torres, spoke up to Rose. They told her they reported it, right?
Yes, I see that statement.
Further down, it says Eli was not allowed to go into the room any longer with SA. Eli did most of the time. She saw him still come in there a few more times. Do you see that?
I do.
Down a little further, Mr. Altman gathers this information that says Eli was somewhat close to another kid. Does not remember his name from the half pint room. Did you do any investigation following up on this of who that kid was?
No, I didn't.
Was Junior / AK in the half pint room at that point, by the way?
I don't know.
Down further,
I do think in these notes, there are notes about he was not close to AK and did not like AK. So I've seen references in these notes to the fact that there was not such a closeness between Eli Tabor and AK.
sure. And in fact, probably Rose Hordahl said that, right?
No, these were teachers. I mean, as I've been going through these notes, there's a lot in these notes that you're actually not drawing attention to that contradict what the things you are drawing attention to. So
Because the purpose of this reasonableness hearing, by the way, is not to go through every single thing, but to show that the settlement was reasonable. But in terms of the conflicting evidence, you would agree that that would ultimately go to a jury to play out in terms of who they believed was more credible, right?
well, she doesn't actually say that the kid he was close to was AK.
Mr. Bolstein, I gotta have you lock on to the
Okay.
question. My question is, you understood that if there was a conflict in testimony, that it ultimately would have been played out in front of the jury about who they believed was more credible, right?
If there was a material question of fact, that goes to the jury for a decision on credibility.
Right, and the greater the level of preparation that one side has in presenting, the more likely that their side is going to be persuasive. Wouldn't you agree with that proposition?
Not necessarily.
And you had one trial where you were the lead trial in a child sexual abuse case at this point, right?
I had 3 trials. One where I was the lead, one was a second chair, one I was a third chair. So, and the one that was a second chair was a 9-week trial. And so it was a pretty substantial experience that I had. So, but the answer to your question is yes, I was first chair for one sexual abuse trial.
So the employee here that we have on page 87 is providing the statement, the kid would hug Eli. Did you dig into that and do any further either depositions or even interview statements about which kid was being hugged by Eli?
I did not know.
Next page, if we would, 88. Aiden Rogers, you see where Peter Altman is collecting that testimony?
Yes.
You see that Peter Altman collected the information that Aiden Rogers, who was an employee of OELC, was concerned about her own son because Eli would change his diapers, right?
I do see it.
And that Aiden Rogers had reported that her son's bottom was bothering him and that she had reported this before allegations about Eli had hit the papers. Do you see that?
Yes.
And did you factor that into your analysis about whether there were multiple potential victims of Eli Tabor at OELC and that this information might be introduced in trial?
No, and this is, I think this is, I'm sorry.
There's an objection. Mr. Lavison?
Leading.
Overruled, that's not a leading question. The question is, did you factor that into your analysis, whether there were multiple potential victims of Eli Tabor at OELC? And that this information might be used at trial?
No.
Did you either go and do a follow-up interview with Aiden Rogers or depose Aiden Rogers about the testimony that she might have presented at trial?
Follow-up interview, I don't know, and deposition, no.
Let's go to page 89. In the middle, just to make sure that we've got clear link. Those statements were taken by Peter Altman that when Eli was in Half Pints, he worked with Junior, and Junior you understood to be AK, correct?
Yes.
Further down, we see in the Mendoza complaint that Peter Altman has taken the notes from an employee that Eli worked with MM in Half Pints. You see that?
Yes.
Let's go on. Page 95, Nicole Alexander.
Okay.
Okay, Nicole Alexander, hang on a second. You see where it indicates that Nicole Alexander provided the statement that she personally saw him hugging SA beyond what was considered normal.
Yes, I see that.
That she heard that Eli was disrupting the sunflowers by visiting SA.
Yes, I see that.
Next page, Ms. Alexander, see the part where it indicates Deanna Harris, one of the supervisors, was fired for coming to work smelling like booze.
I see that, yes.
Okay, next page. Page 97. Let's go to 99. The statements provided by Shiante Brown. Actually, let's go to page 100 of her statement. Give you a chance to look at that.
Okay.
The section in there where Ms. Brown indicates that Eli had gotten into trouble with marijuana. Do you understand that to be at OELC?
I don't know. I don't recall.
In the middle, she provides some statements about Steve Olson, never really met him, saw him downtown. Perception was that he did not care. Most people felt the same way. If he cared, rose with them. You see that?
I do.
And did you evaluate that as you took over representation of Steve Olson as a defendant in the case?
No.
Did you talk to Steve Olson about the perceptions that employees had of him as an uncaring director who sat in his office playing solitaire when you took over his defense?
I did talk to him about the perception that he was not actively involved in the management of OELC, and he denied that.
Bob, I want to take a look at this section. From Ms. Brown, she gave a statement after Eli and SA started hanging out, things started to get weird. We got awkwardly possessive around SA. And she told that it was weird. Emily reported it to Rose. Emily claimed he kissed SA on the lips. Do you see that part?
I do.
Page. Red flags concerning Eli's behavior. she actually saw pictures, Ms. Brown's indicating to Peter Altman that she saw pictures of Eli and SA on Facebook.
Just say no, but speed up when you're reading.
Where we at?
Okay, Peter Altman.
That she saw pictures of Eli and SA on Facebook, right?
I see that, yes.
That Tabor is calling SA his baby, right?
I see that.
That she saw SA lying on the ground, that she saw him lying on the ground with SA rubbing his back, saw him kiss SA on the lips, told Eli it was inappropriate, and Eli said it was fine and she was being over dramatic. How did you factor that in terms of your defense theory for this?
I thought that these were all problematic red flags that would likely result in a liability finding if liability was contested.
Over on page 102. Down under the Steele Thompson Barbieri complaint.
See that? Okay.
You see Ms. Brown confirming that Eli Tabor did work in the same room as where JT was at. Highlight that on the board.
Oh, it's actually, it's not visible on the board.
Right in the middle, where it says
I thought,
she worked with JT only a little bit, saw it, same with Jello. The Christy Barbieri part was what I was looking at. Eli worked with her, he was a sub, and he'd been demoted to sub. You see that part?
I do.
And by the way, did you understand plaintiff's expert, Dr. Matt Logan, would talk about Eli Tabor being opportunistic and self-loathing in a way that might cause him to engage in deviant behavior that he might have thought repulsive.
I recall that you sent me Matt Logan's report. I don't recall it in that level of detail.
Let's turn to 104 where we got Sonia Riley and Clifton. And I think you indicated that you are the one who did this interview. Is that right?
I did interview Sonia Riley.
Tell us what you remember about this interview.
But I think that this might be a separate interview that Peter did.
Well, let's start with what you remember of your interview.
I interviewed her at the West Side facility, and I recall that she observed uncomfortably close behavior between SA and Eli Tabor, and that she confronted him, and he told her that stay out of it. It was none of her business, and she was concerned about the nature of the relationship.
Did she tell you that she thought his behavior was grooming?
I don't recall if she used those words or not.
Did she tell you about whether she thought that Eli Tabor was capable of sexually abusing the girls?
I don't recall that.
Let's turn to page 105. Remember Sonia Clifton telling you about Steve Olson liking to hide in his office?
I do recall hearing that kind of testimony, as I've already testified to. I don't recall firsthand whether she was one of the people who said it.
Now we're confirming it though, right?
This may be what she told to Peter Altman. I don't know if she told that to me or not.
Down at the bottom, we see some more of the body of what Ms. Clifton had to say, including that she confronted Eli and that she told him that Rose knew about the allegation of near close abuse but did nothing. She told people to shut up unless people could hear them, right? Well, see, I'm just confirming that.
Oh, I'm sorry.
Confirming that Ms. Clifton told at least Peter Altman that Rose knew about it and told people to shut up unless they could prove it.
Yeah, that's what it says here.
Okay. On the next page, we have a section of Ms. Clifton's confrontation with Eli about his behavior. She told Eli she thought he was grooming, that she had a previous experience with life force and work with sexual predator training. Life force, and working with sexual predator training. By the way, did you talk to her about the fact that she had had a situation where her own daughter was sexually abused?
Yes.
And did you ask her whether she had filed a lawsuit on behalf of her daughter because of her sexual abuse?
I believe, I mean, I do recall this coming up in my conversation with her, and so probably.
And did you learn that her attorneys were Mr. Conley and myself in that case?
She mentioned Jack Connolly. Sorry, Mr. Cochran, I don't recall you coming up.
Did she talk to you about the result in the case, a $4 million settlement for her child's sexual abuse?
No, she didn't talk to me about the amount of the settlement.
Did you go in and take a look at the lawsuit at all and evaluate what had been done and did?
No, I had no interest in learning more about her lawsuit.
Did you explore with her the nature of the sexual predator training that she had received prior to working there at the Olympia Early Learning Center?
If I did, I don't recall.
Did you gather the same information during your interview that we see here that Peter Altman did?
Some of it sounds familiar to me. So some of it that I can recall from my interview with her as well.
For example, did you learn that Sonia Clifton firsthand knew that Eli Tabor was closing the room down for Big Eli, who was sick on the day that JT disclosed that her vagina had hurt?
No, she didn't tell me that, and I don't recall hearing that from anyone else.
Okay. Though you did get the interview notes from Peter Altman and reviewed those at some point, right?
Objection, argumentative.
I don't actually.
Overruled, you may answer.
I'm sorry, I don't know where you're referring to. There's a lot highlighted on this page.
Sure. During the time when SA was with the Half Pints, Eli was a sub. First girl vagina allegations against Eli Nelson. Eli was closing the room down for Big Eli, who was sick. You see that?
That's Big Eli was not sick on the day of the allegation, as far as I can recall. I don't know what this statement refers to, but I don't recall this having to do with that same allegation.
Did you ever go and talk to Eli Tabor, by the way, about that?
Yeah, no, I did not.
Did you depose Eli Tabor at any
No.
point? Did you either talk to or depose Eli Nelson at any point?
I did not talk to Eli Nelson, and I know Peter was attempting to talk to him.
You did learn from Ms. Clifton that she saw Eli give a lip-to-lip kiss to SA at OELC, right?
I do recall that there were things about their relationship that made her uncomfortable. I don't specifically recall if she told me that.
Over on this next page, you can see if you see the note that Peter Altman took as one of the attorneys for OELC from Sonny Clifton that she thinks Eli could have abused the videos, right? See that?
Yes.
And did you broach that issue with her when you talked to her?
I don't recall if I did.
All right, Mr. Bolsey, we're going to switch focus here, and I'm going to have you take a look at Exhibit 74, which should be in the second binder. Got with your permission on published 74.
Yes.
Okay, I have it in front of me.
October 21, 2011, you would have been on the case at this point for what, roughly 5 months-ish? 4 months-ish?
Yes.
We can tell from the letter from me to you that we've apparently just taken Steve Olson's testimony regarding insurance coverage. Do you remember Steve Olson knowing anything about insurance coverage other than what you might have communicated to him?
I don't recall the substance of his deposition on insurance coverage. And if that was true, then it would have been he would have been able to testify to very little.
Right. In fact, you remember him at the deposition saying, I only know what I've been told?
No, I don't recall the substance of his testimony on that issue.
In this letter of October 21, 2011, you see that I am asking for information about the insurance coverage and discussing information about insurance coverage.
Yes, that issue is raised in the letter.
Okay. In fact, you and I had correspondence about it or discussions about it on a number of occasions throughout the entirety of the litigation, right?
There were a number of discussions we had about insurance coverage.
In this particular letter, you became aware, or from this letter, that I was seeking to nail down the coverage, including going to potentially depose the insurance brokerage for OELC and the insurance company for OELC, right?
Yes, that's what the letter says.
Did your client's OELC, like John Masterson, for example, board of directors, did he oppose my efforts to try to get clarity about the insurance coverage?
No.
Did Steve Olson or Rose Fordahl tell you not to advise me or help me understand what the insurance coverage was?
No, I would have thought that was a positive development in the resolution of the cases.
Did any of the three defendants at any point say, Mike Bolasina, our lawyer, we want you to assist in filing a motion to quash efforts to take depositions of either Philadelphia or the broker on the issue of coverage?
I never got that message from any of those three.
And I think as you pointed out, it would have been in their interest to have that clarified, right?
Well, to get you more information about insurance coverage was, I thought, a positive development towards settlement.
In this letter, I had mentioned in the previous dealings with Philadelphia Indemnity. Do you see that?
Yes, I see that.
And did you understand from my letter, particularly on the second page, that in my prior dealings with Philadelphia Indemnity, that they had misinterpreted their policies and that it had come to fruition that they had much more coverage than they let on.
Objection. These are leading questions and a testimony from Mr. Connolly, Your Honor.
Well, the question is to the witness, did you understand that's what I told you? So the court is not accepting as factual any of the representations of Mr. Cochran. Rather, Mr. Cochran is asking the witness if the witness recalls Mr. Cochran providing information to the witness regarding Mr. Cochran's prior experience with Philadelphia indemnification.
It says you may already know that you tangled with them over coverage issues. I do recall having a conversation about that with you in your office. And if our conversation occurred before this letter, then I would have already known. And if not, it would have been news to me.
Did you follow up with anyone about the information that I gave you as to BCTI and Philadelphia Indemnity's past interpretation of policies?
I think I actually raised it with Jackie Holloman because I had discussions with her about the disputes over coverage limits. And I believe I told her that you had litigated against Philadelphia Insurance Company before and felt that based on that litigation that their coverage limits were higher. But I did not do any independent research into that issue. I think at one point invited you to provide more information about that so that I could pass it on.
And do you remember what feedback you got from Philadelphia Indemnity when you raised that issue with them?
I think that she just said that she wasn't aware of it. She would look into it. Something general like that.
Maybe turn to Exhibit 75. While you do that, let me ask you, did she ever follow back up with you on the issue of whether Philadelphia Indemnity had misinterpreted the BCTI policies?
I don't recall any conversation about that again.
You haven't seen any email traffic between you and Ms. Holman that ever followed up on that, right?
I don't think so.
So Exhibit 75, Your Honor, I'll present that to you. Will allow me?
Yes.
This is a December 1, 2000 letter from myself to yourself, is that right?
Yes.
Understood this to be a policy limits demand on that day?
Actually, this is the letter that I do not have any record of receiving, either in my hard copy file, my memory, or my email. I think I first received this letter after the consent judgments were entered, and Jackie Holloman called me about it and asked me about this letter, and I didn't remember it and couldn't find it in my file.
Actually, is it true that you, let me ask it this way. Do you remember actually having sent an email at a point down months later where you say you are referencing your earlier policy limits demand? Yes, I remember that.
Yeah, and I actually, when I sent that email, I don't think that I actually looked through my files. Again, this was all reconstructed after the fact, but I suspected based on our conversation and the letter that is exhibit number 74 that I thought that maybe this is what you were referring to.
Okay, so hold on. So here's exhibit 75,
All right.
which is the December 1, 2011 letter. At least I drafted it. It says Mike Bolasina, Olympia, Early Learning Center policy limits demand. Did I have the address right, by the way?
That is correct. That is the correct address.
Okay. And then let's turn your attention to exhibit 72. Your Honor, I'll present that.
Yes.
These are July 20th emails that we looked at with Mr. Connolly. But you'll see where I say at 3:03, and I'll highlight it here up on the screen. Mike, I wanted to make sure somebody over at Philadelphia Indemnity let you know that the motion for protective order was granted, so the debt is off for Monday. I also wanted to make sure you received our policy limits. And went on to say, hopefully somebody out there is communicating with you. And then you responded up here. Thanks for the info. I had not heard. Policy limits demand. Why don't you go ahead and read that?
If you mean a recent demand, no. If you mean a 4 million demand from a while ago, yes.
Between December 1, 2011 and January 20, 2012, had I made any policy limits demand?
I don't know, but I wasn't aware of the letter in December. I was aware of the letter in October and our conversation. And I think that I passed that on to Jackie Holloman saying, you know, you think that the policy limits are at least $4 million and that's what you want.
Okay, so I don't want to talk about October of 2012.
Okay.
I want to talk about December of 2001, 2011, which is exhibit 75, and July 20, 2012, where you're saying, if you mean a 4 million demand from a while ago, yes.
Yes.
What were you referring to?
I think I was referring to the October letter as well as a conversation that we had on the subject of policy limits and what you would take.
Let me ask this. If in fact you had received the December 1, 2011 policy limits demand letter that we see in exhibit 75, that should have been discussed with your client, Olympia Early Learning Center and its board, right?
Yes, and I actually did have discussions with them about that issue.
Sure.
Many discussions.
Let me just stay singularly focused on this.
Okay.
December 1, 2011. If that had been received by your office and you were aware that it had been received by your office, you would have been responsible for making sure that was communicated to your client, right?
As well as to Philadelphia Insurance Company.
Right. And in fact, Philadelphia Indemnity would have had a responsibility to have responded to it in some fashion, right?
Objection calls for legal.
Sustained.
Would you have expected that Philadelphia Indemnity would have directed you on how to respond?
If they wanted to respond, yes. Sometimes they get a settlement demand and they just like, you know, don't respond to it.
Understood.
So.
And of course, they do that at their peril, right?
Well, I don't want to get out of my lane. I'm not an insurance coverage attorney.
Fair. Your Honor, I'm going to take us back to 75.
Yes.
Okay. Mr. Wallace, I want to just take a look at the second page. And at this point, writing at this point that I felt that at that point, and maybe not with all the plaintiffs in the case yet, I think JJ was later on, that I felt that the claims greatly exceeded $10 million. Do you see that?
Yes, I do see that.
Let's go to exhibit 66. I'll present that.
Yes.
Mr. Wilson, tell us what exhibit 66 is.
This was a letter that I wrote to Jackie Holloman, basically giving my thoughts on both facts, liability issues, and damages issues.
And its purpose is to what?
Provide her with information about my opinions and thoughts.
Okay, on page 2, you indicate that Tabor had performance and disciplinary issues throughout his employment with OELC. And you go on, as we see here, he was written up approximately 10 times for failing or refusing to follow rules, such as remaining in his assigned classroom, right?
Correct.
Obviously, it goes on. There's one, you indicate, there is one disciplinary matter that is of particular concern. During the CPS investigation, an employee or former employee provided the CPS investigator with an unsigned 2009 reprimand for violating policy and lying down with SA, one of Tabor's victims. And you felt that was problematic for the defense theory, right?
It is, and actually, there's a typo there. It's actually a 2010 reprimand. It's not 2009.
But you, I mean, at least at the time, you thought it was 2009 because you went on and repeated the 2009 memo court part, in a sentence that says Ms. Hordahl denies that she knew about the 2009 memo. Right?
Yes, but it's a 2010 memo, so.
Turn your attention to page, let's go to page 6. I don't think there's any doubt that you've made clear that you thought SA was a valid defense case, right?
Correct.
In fact, you indicated that you considered just admitting liability.
Well, that's, that would be something to discuss with the clients as well as with Philadelphia, but that would have been my advice.
But beyond just the SA case, you note in this liability issue section, witness interviews and review of the CPS investigation file reveal that many of the OELC teachers observed conduct by Tabor toward SA that was suggestive of an inappropriate relationship between them, right?
Is that yes?
So, of course, the
Yes?
CPS
Sorry.
files.
Sorry, is that a yes, Mr. Bolasina?
Oh, I'm sorry, it is.
Thank you. Please continue.
CPS file was corroborative of the abuse and the evident nature of the inappropriate grooming relationship that Tabor had with SA. Right?
Yes, there was substantial evidence of him engaging in red flag behaviors at OELC.
Right. In fact, on page 7, you go on and talk about that. Again, you say that Tabor's employment with OELC was problematic even without the alleged concerns raised about his relationship with SA, right?
Yes.
Again, you reconfirm that he was repeatedly disciplined for violating workplace rules, such as remaining in the class to maintain a legal teacher-child relationship, or ratio, right?
Correct.
Next page, page 9. Oh, let's go to page 9. Here you address the damages issues in the case. You point out that the most significant damages is SA. Tabor pled guilty to sexually molesting him on many occasions. You say that there were several instances of oral sex, but you remember yesterday when we actually showed the admission from Tabor that it was 10 to 30 times of oral copulation rape, right?
Yes, I recall that.
And you point out it is rare to have a case where the victim of abuse is this young, and the extent of the abuse, both in number and in severity, was so great, the jury is likely to conclude that SA was significantly damaged by such conduct, right?
Correct.
I wanted to take a look at the parents. You actually addressed the parents, the damages of the parents. We see in here that you say that the damages to the other children are minimal. And again, let me confirm, neither at this point in time in February of 2012 or in September of 2012 did you have any damages experts prepared to testify at trial. True?
That's correct.
Right. As to the parents down there, you say the damages to the parents are more significant. The parents may legitimately believe that their children were molested, and this may have been a significant stressor for them. This is particularly true for the Steele-Thompson parents, who tended toward, you call it, suspicion, paranoia, and a helicopter style of parenting. You go on to note for Philadelphia, under Washington law, parents can collect damages for damage to the parent-child relationship as a result of the tortious conduct. However, you say they do not collect damages for emotional distress damages arising outside of the parent-child relationship. So you were acknowledging that the parents may be able to make out a significant claim to the jury. Right?
Yeah. Actually, what I was acknowledging is that at least some of these parents truly believe that their children were abused, and that would be a stressful incident for them.
Right. And that the plaintiffs would get to present that case to the jury for the parents, right?
Yes,
Let's turn to Exhibit 116. And Mr. Bolsi, let me know if that's in either of the.
it is not. I need another book.
Okay, let me switch those out.
Yes.
It's in the supplemental. Thank you. So that status letter we were just looking at, by the way, was February 21 of 2012. You have Exhibit 116 in front
I
of you?
do.
And you're going to present 116?
Yes.
Tell us what 116 is, Mr. Bolsi.
It is a litigation budget I prepared at their request.
You know, this might be a good time to stop, Mr. Cochran. It seems like perhaps the line of questioning has taken a different tact. And it's now 11:42. It's apparent to the court that additional testimony of Mr. Bolasino will be requested by both plaintiff and the intervener. So the court recalls yesterday Mr. Bolasina advising that he had an obligation to be, I think it was up in Everett sometime this afternoon, and accordingly would not be available. And the court recalls advising the parties that in light of that double booking, the court was inclined to reconvene this hearing when Mr. Bolasina was next available, and the court was available and the parties were available. But I want to get input from the parties in that regard. And then as a result of Mr. Bolasina being unavailable this afternoon, the court anticipates it will not be back in session until some later date when all of the parties are available, including the court. Mr. Cochran, what are your thoughts in that regard?
I just understand the court's position on this, and that everybody needs to be fluid about it. Our preference would be to do it as quickly as we can. Understand the court's got a schedule it's got.
Okay, thanks. Mr.
Same, Your
Robinson?
Honor.
Okay. Well, the court appreciates the cooperation of the parties in this regard. I'm going to advise the parties of the court schedule. I'm going to do that off the record. Let's go off the record, right? So I have a surgery scheduled for September 30th. That's a Thursday. So I'm not going to be back until, I think, October 7th. But after that, I'm pretty sure I can be flexible and fit you guys in for a block of time or piecemeal. And I'll talk to my JA about that, and I'll have her just communicate with both parties to see when we can reconvene. And I'll ask the parties, of course, to receive input from their witnesses as to their availability. And then I'll put the onus on my JA to put it all together. I hope that makes sense.
It does, Your Honor.
Okay, and let's go back on the record. The court is back on the record after having an informal discussion with the parties regarding the court's availability in the near future. The court will advise or ask its judicial assistant here in a matter of moments before noon, because she goes to lunch, to communicate with the parties regarding the parties' availability to reconvene this hearing. And I'll leave it at that, and I'll allow the parties to place anything on the record that they would like to place on the record before we next convene. Mr. Cochran?
As I mentioned, off the record, plaintiffs understand the court's need for flexibility, and obviously we've imposed some need for flexibility on the court, and so we'll
Thank you. Mr. Levison?
I do know, Your Honor, that I'm out of state from the date of your surgery until the 17th of October.
Okay,
I think I have one hearing later in the month, but I'm otherwise pretty available.
okay.
And I don't know about my colleagues.
Okay, I'm going to be out of the loop in that regard. because like everyone here, I have other work to do. And I understand and appreciate that all of you have other work to do and other schedules, including Mr. Bolasina. And I was a lawyer once. I'm still a lawyer. I'm still a lawyer, but my role is a lot different. I remember what it was like to have to be in two places at the same time and how stressful that is. I also understand that just because you're in trial doesn't mean that your practice or your other responsibilities stop. You have other things you have to do, other obligations. I also understand, frankly, time is money because, yeah, I understand that and appreciate it. So the court's going to be off the record and in recess until we next convene. The court again expresses its appreciation to the parties for their personal and professional courtesies. Thank you. Court's in recess.
Guys, what is on me?
See you again, Mike.